Finally, on case number 4, we'll look at a prevalence of foreign trusts that are locally administered in Singapore and whether or not these foreign trusts import greater levels of protection than we are afforded in Singapore within the Singapore trust context, and whether or not these are going to be enforceable going forward. Now, this is an interesting one because we obviously have the phenomena of foreign law trusts being locally administered in Singapore. I don't know if there's any actual statistics out there, but they do exist and they are here. And the question is, will protections contained in a locally administered foreign law trust be enforceable in Singapore, particularly in a context where a Singapore court is exercising its supervisory function over, let's say, the protector or the local trustee, and all of the assets, let's say, are in Singapore, and the beneficiaries are in Singapore, and the only thing that's foreign is the proper law of the trust. And I say that because of the Crociani decision in the Privy Council. Now, this is obviously conjecture, okay? So there's no right answer here. But the question being asked is, could a Singapore court looking at the facts of the particular trust and looking at the fact that it's the only foreign element of it is the proper law, seek to apply Singapore law to the circumstances of that trust and disregard the terms of the foreign law provisions, particularly, let's say, dealing with liability exposure of a protector or a reserve power holder. So I just wanted to get a feel for what we felt the Singapore's court's approach would be if we do have a scenario where the foreign law provides much more protections than a domestic Singapore trust would provide, and but all of the parties are in Singapore. Would it be possible, on the basis of Crociani, for the Singapore court to maybe disapply some of those provisions? I'd ask Lin Chuan, what's your view on this one?
Yeah, I mean, I think starting point would be sort of, you would have a characterization question as a matter of PIL, private international law, as to what issues are governed by the local law versus the foreign law, right? So some provisions might be outside the scope of the trust itself. For example, if somebody challenged a particular transfer into the trust, then in that sort of situation, whatever clause on jurisdiction you had and so on, and governing law would not help you. Then you have a sort of a group of clauses that are dealing with largely internal claims, and beneficiary claims are largely internal claims. Then in that cases, I think the proper law would be followed to the extent that Singapore's own general PIL principles would point there. Whether jurisdiction, if you did require only the foreign court to have jurisdiction, whether that might be followed, I think that is less clear, because court has the discretion to maintain jurisdiction, and an exclusive jurisdiction clause may not bind the beneficiaries to the same extent, right? That's a nice debate about how far you can do that, even in the case of trust arbitration clauses. So different clauses may have different impacts, but I think on proper law we would apply our PIL. The override to that is quite limited. It's public policy, but that's quite limited. And a simple example of that, not perhaps related to breach, is if you have a clause that is perpetual, right? A trust that is perpetual under foreign law, and you administered that here, would that work? I would say probably it does work, and there are stacks of Jersey trusts that are administered by Singapore trustees. So many things would point to PIL, and there is a possibility of a public policy override, but it's probably not that wide.
And any views, Victor Woodham, on this one?
I'll just add in maybe to explain to the attendees the difference, right, between a situation in a trust and a normal contractual provision, right? So in a normal contractual provision, you would not have the Singapore courts saying that the law which was governing law, which was chosen, which would apply, right? Would apply. But in the case of trust, you know, and I think there's an argument that the Singapore courts, or the courts in general, have an inherent jurisdiction to supervise, and the weight to be given to such clauses is less than in contractual cases.
Correct.
But I would think that the default position would be to still recognize the governing law provided, and then, you know, maybe in very, very, very narrow cases to persuade the court otherwise.
Wenham, any views on this?
Yeah, I concur. So we look at it at different levels. Number one is privity of contract, and so if the contract is made, it's valid, the courts would generally give credence to what was the choice of law expressly stated. So if there's no challenge to validity, that there was fraud, or the person did not have mental capacity to choose the right law, so then that would be given. So the default position would be that foreign law will be recognized, and you call for foreign legal experts to give the evidence. And I agree with Len Chuan and Vigna that by and large, the Singapore courts would allow the foreign legal provisions to apply unless it's clearly against the Singapore public policy, which is extremely difficult in the case of a private trust.
I mean, Tony, from your perspective, what's your view on administering foreign law trusts in Singapore? Do you worry, or what's the issue internally on, can we rely on all of these provisions in Singapore? Do we worry about the potential for Singapore to disapply any of this? Yeah, as part of this function.
I mean, I certainly think that there's a risk that they won't. I do, from a practical point of view, I do think that we take the view that what you need to really look at is the original intention and the original purpose of that trust structure. I think if you look at the Quachiani case, I mean, there was so much shape shifting with, you know, with that scenario that it was almost incumbent on the Privy Council to step in and do something about that. And I would think and hope that the Singapore, you know, courts would, you know, would do the same. But I think if all going, you know, all being equal, if the trust is following its original, you know, intention, even if, you know, and even if the settlor wanted to change it afterwards, if we actually stuck and enforced that original thing, I think the courts would you know, would apply the foreign law.
Right.
Well, I'd hope they would.
Yeah.